I actually, in my contract for this, I have a 20-minute introduction, so I hope you don't mind.
Go for it, Eric.
Everyone will walk out. Just really quickly, my name is Eric Crusuis. I'm a partner at Holland & Knight. I sit in our government contracts and cybersecurity groups. Really glad to be with you all today. I'll pass it over to Michael to introduce himself.
Hey, good morning, everyone. My name is Michael Gruden. I'm attorney at Crowell & Mooring, also sitting in our government contracts and our privacy and cybersecurity groups. Excited to be here this morning. This is my third event over at the CMMC Ecosystem Summit. I think the third year here now, so I appreciate the opportunity to be back. I have the privilege of working with a lot of leading defense contractors and counseling them on applying the various government's cybersecurity standards. Prior to working at Crowell, I actually worked for the federal government for 15 years as a contracting officer. First at the Department of Homeland Security, and then at the Department of Defense, where I was a Pentagon IT Acquisition Branch Chief. So this morning I'll put on my figurative CO hat and help navigate some of the government's increasingly complex and sometimes confusing cybersecurity requirements. I also have with me a really great friend, Chris Page. He is the Assistant General Counsel for Huntington Ingalls Industries, the nation's largest military shipbuilder. Chris supports all aspects of cybersecurity, artificial intelligence, and privacy for HII. He also provides legal counsel to HII's Chief Information Officer and is a member of the company's board of directors. In addition, he coordinates and oversees HII's enterprise-wide supply chain cybersecurity compliance and risk management program, referred to as SC3 RMP, and previously he supported HII's divisional supply chain organization. So I'm pretty confident Chris can talk to us about supply chain today from a general counsel's perspective.
Thank you. Thank you for having me.
Great. Well, let's get started here. So CMMC, of course, didn't fall out of the sky. I know a lot of folks in the room here have been following this initiative for 5 years, 7 years. It probably seems like 30 years at this point, but it's been a long while.
It's been a while.
Yes. But it didn't start with CMMC, of course. We had some other DoD regulations that preceded CMMC. We had the 7012 clause, as a lot of folks know it, which required the same controls, but contractors were essentially self-certifying by taking on the work that had the clause in it. Then we had the 7019 and 7020 clause, which requires companies to go into the supplier performance risk system and talk about how many of the controls they're compliant with. So larger picture, Michael, we'll go to you as you're in your contracting officer hat here. And I won't blame you if you break into your private attorney hat as well. Big law private attorney.
I'll switch from one to the other.
Yeah.
I'll put them off and put them on.
You should have had two hats.
I should have. Next time we'll do that.
Where do you kind of see this larger picture coming from and going to?
Yeah, I mean, thanks for that, Eric. I mean, I think when we look back over the last 10 years, to the point that Eric mentioned, the DoD really tried, and the contracting officers tried to secure the government's data, the warfighter's important sensitive information. And the government really found that what they were doing wasn't working. When they originally released the DFARS 7012 clause 252, 204, 7012 back in 2013, if you can believe it, they issued that with good intentions of thinking, we're going to release this clause, it's going to be implemented by industry, they're going to adopt all 110 controls of NIST 171, we're going to shore up this vulnerability, we're going to see a decrease in theft from nation-state threat actors to our regulated data, but it didn't happen. I think the challenge that I think the government quickly identified was if they continue to sort of push out implementation deadlines, which they did for multiple years, that industry is going to continue to sort of wait until it's required, and that even with that, with the allowance under the 7012 paradigm, to have open controls, having plans of actions and milestones where you didn't have to implement all of the controls, nor was there even specificity with how many minimum controls you had to implement. There was a great degree of deference and vagueness. And with that, again, sort of putting on my attorney hat, that can be really beneficial. Again, if you're counseling clients of saying, well, here really is the legal compliant requirements. There was a lot of flexibility, and I think industry took that. But I think, again, putting on my CO hat, I think what the government was seeing is, again, this wasn't working because we're not incentivizing industry enough. And so their initial step to do that was implementing through the DoD's interim rule in, was it 2021, the DFARS 7019 and 7020 clause requiring self-assessments, assessing yourself, scoring yourself, and uploading that score into the supplier performance risk system, which essentially is a representation, an official attestation to the government. So there was a legal hook, and the government thought, okay, this is going to get us there. And I think that they did that with good intentions. But in the meantime, concurrently with that, there was CMMC 1.0, which I'm sure a lot of you were following back then. Again, there was subsequent rulemaking, but I think with that, the intention was there needs to be more than even just a self-assessment. There needs to be independent auditing to really verify that the government is getting it right on behalf of industry because they want to shore up that vulnerability. And Chris, I don't know from your vantage point what that was like, in your role as a GC as you saw the evolution of that.
Yeah, so, I mean, obviously 7012 as a prime contractor, right, we're initially getting the clause like we get all the FAR and DFARS clauses, flowing it down, and that's it, right? I mean, in the beginning. But as the clause progressed, as you see a lot of issues arising cyber-wise, and in that industry, it starts really coming to be where, I won't say all the prime contractors, but a good majority, at least in the defense industrial base, decide, hey, we need to do more than just flow down the 7012 clause or the 7019 or 7020 clause. There needs to be some more rigor internally in terms of compliance and risk assessments and outreach and partnership with the supply base to make sure that we're not just flowing down a clause and sticking our head in the sand and hoping for everything to turn out great, because we know that's not how it works. So that was kind of the progression in for us anyway, the 2017, 2016 timeframe, kind of standing up this supply chain cybersecurity compliance and risk mitigation program, which involves going and adding some language to our subcontracts and supply base purchase orders, requiring some suppliers that handle CUI to be part of this program, and we have a third party. We use ExoStar, right? So there's a number of different questionnaires that we have in our portals that we require those specific sub-tier or subcontractors to go in and fill out, and then that comes back to us, and then it goes into our machinery to figure out, what they look like from a cyber risk perspective.
I have one curious follow-on question on that too. Speaking again, I'm really intrigued sort of from an industry perspective. What was the reaction or sentiment of CMMC being finalized even within the last year, where now we have 32 CFR, we know that it's imminent. If you were already doing, a lot of this under 7012, under 7020, is it a big deal?
I do. I think it is a big deal from the certification standpoint, right? There's, in theory, we're going to be able to get whatever level the supplier's going to be at that rolls up under our respective prime contract. We're going to be able to get a certification that either they've done a self-assessment or they've had a third party, a C3PAO assessment. I mean, just a little bit of background. Our world, my world, is really, I'm really concerned about level 2 and level 3 CMMC compliance. I'm not really, given our industry and what we do and what we build, concerned about level 1 so much. So in that regard, level 2, we'll say, a good majority are going to have to be certifications versus self-assessments, maybe not in the beginning, but in the execution phase or the up and running phase. That in level 3 even more so, right? So I think to answer your question, yeah, it is a big deal from that standpoint. We're going to get a certification. We're not going to have to, get a whole bunch of questionnaires in from various suppliers and then go kind of do our own homework on what we think is risky versus not risky, right? So I think that's the benefit.
So that kind of that standardized process,
yeah,
that will be much more helpful.
Yes.
I want to talk a little bit about the rollout. The rule kind of specifies a rollout period of time that's going to take place over 4 or 5 years, but I kind of want to point something out that I think is really interesting with this rollout. Right now, Michael ran through and did a great job of doing that, the iteration of the different clauses that we've seen that have put additional, say, burdens on contractors to demonstrate their compliance. So the one that came out a few years ago, the 7019 and 7020 clauses that require contractors to go in the supplier performance risk system and say how many of those 110 controls for level 2 are they compliant with, or for under the DFAR 7012 clause are they compliant with. And a contractor goes, puts in a score of 50. Maybe they put in a negative score in some instances, right? And DoD keeps doing business with that contractor, and that's up to my personal belief, that's up to DoD at that point. The DoD is now taking the risk knowing the lack of cybersecurity controls that a contractor has when they put that score in. But then we have this 4-phase rollout that's coming. Phase 1 which is on the effective date of the Part 48 rule, CFR Part 48 rule, which will be sometime the first half of next year, requires level 1 and level 2 self-certification compliance. And it was very clear in the rule that level 2 self-certification means you have 80% of the controls in place, which is 88 controls. Quick math, 110, 80%, 88. And there are certain controls that can't have plans of actions and milestones. So that's a sea change for contractors, right, that have these negative scores, that have these lower scores, where they're still doing business with the Department of Defense as a supplier or as a prime contractor. But then when phase 1 rolls out, that's not going to be possible anymore, right? They're going to have to have those controls in place. Michael, like, as a contracting officer, how do you deal with kind of the inevitable problems that would arise with something like that, where there's a big change like that?
I mean, I think the large part is sort of, from a CO's perspective, is we're relying on the prime. Again, we're including these, unfortunately for you, Chris, sorry. These clauses are then going to be included, the 7021 once finalized in 48 CFR, ideally early 25. Once that hits, the burden really then falls on the prime contractor, that as the CO, again, as a former contracting officer and a branch chief in the Pentagon, I would issue the contracts and I would tell prime contractors when they're coming to me and they're complaining about an issue with their subcontractor, I'm saying, that's between you. The government really takes a staunch perspective that they have privity alone with the prime contractor, not with a sub, not with any lower tier suppliers. And so that burden and that responsibility really all rests on Chris's really strong shoulders over here.
Yeah. Yeah, and that's very convenient for you as the contracting officer to do that. I would agree in part. I would also say, though, I think that really highlights the benefit of kind of the early work that we're doing is getting with your program contracting officers.
Completely agree.
Which we've already been doing, to kind of have that dialogue and start talking about what some of the potential risks are, what the different certification levels are going to look like for various contracts and programs. So it's not, during the solicitation or the negotiation aspect of a specific contract where we've already had those dialogues and they know the risk, right? This is going to happen, right? There's going to be situations where a specific high-profile contract or big-time program has a bunch of supply chain risk in terms of that you've just talked about. They can't meet whatever level they need to meet, and so having those discussions on the front end and kind of level setting and right setting the expectations. Granted, yes, it's still at the end of the day, as a prime contractor, these certification requirements or condition of contract award. I get that, but having those dialogues ahead of time will help.
And I like, honestly, what you called out, and I want to highlight for the audience that you didn't say you were going to reach out to the contracting officer. You said you were going to reach out to the program office. And I think that that's pivotal. In other industry events I was speaking at recently, someone was asking about my vantage point as a CO and really how to engage the government. And I was saying, if you're only talking to the contracting officer, you're doing it wrong. The CO has obviously the authority to bind the government, but the person that's really driving all the requirements really is the program office. And so to Chris's point, if there are prohibitive requirements, in your contract or within your supply chain of how the government is flowing down the contracts and saying everything is CUI, where in actuality it might be a subcomponent of that contract performance, if they're overly marking, for instance, and then that is prohibitive to you performing under the contract, you're really benefited by actually engaging the program office itself and saying, we cannot perform this function the way the contract is currently structured. And that could occur through industry engagement, a pre-solicitation kind of conference, a Q&A phase of solicitations, or even a mid-contract review. And I'm sure, Chris, you have experience with all those.
All of those, and we're exploring all of those and actively working on them to try to make sure that risk is at least identified, right? It's not ever going to be perfectly mitigated because it is a risk. But having those discussions on the front end absolutely will help mitigate.
Yeah, very impactful.
Yeah. Chris and Michael, you, whether as a private attorney or a contracting officer, deal with a lot of small businesses. There are a lot of folks in the room here who are either parts of small businesses or work with small businesses as part of the ecosystem. They obviously face unique challenges. They don't have the same wherewithal as larger companies do. Maybe getting a CMMC certification is not worth it to them based on the business that they have. Chris, how do you deal with those kinds of challenges with small businesses in the supply chain?
Yeah, so we have at any one time, between 3,500 and 4,000 suppliers, as you might imagine, building nuclear carriers and nuclear submarines, along with a number of other ships. And so we have a fairly large portion of middle to small sized suppliers from tier 1 all the way down to the mom and pops. And we're in this kind of readiness phase, this planning phase before 48 drops, but have those discussions, we've had those discussions with them in terms of, hey, what are your thoughts on CMMC? What are you looking like, right? Like I said, we have our internal infrastructure in terms of our supply chain cyber compliance program, so we kind of know the suppliers where they fit in that continuum. And then identifying which ones that we, are critical, that we need to go out and talk to them. And, have you started down this path? Have you started with, any type of internal preparedness? Do you have a registered practitioner in mind that you might want to help come in and look at some of your artifacts, make sure you're on some good solid footing before you go down this path of, a level 2 or level 3 certification. So it's that dialogue with, obviously with that broad volume of suppliers, we can't go out and talk to all of them, but kind of risk-based approach, criticality approach, going out and talking to them and having those dialogues, again, make sense at this point in time.
And I think you raise an interesting point of that dialogue flowing both ways. To Eric's point, we counsel a lot of manufacturers and suppliers, up and down the supply chain. And often when we're counseling those sort of lower tier subcontractors, they do face challenges of really understanding the technical requirements, saying we have inability to apply this broadly throughout our environment, or we don't really know when we're handling CUI or not. But interestingly enough, something that stood out to me on Tuesday at our offices, we actually hosted Stacy Bostjanik, the CMMC program director, for a fireside chat. And during that discussion that we had with her, she was also really putting the burden on the supply chain itself in terms of identifying only the relevant information that needs to be flowed down to those lower tier subs, so that you're not providing the kitchen sink when you only need, a can opener, so to speak. So again, to the degree that you can limit CUI, I think it behooves everyone. It benefits the prime, and I think it also benefits the sub, that they're not then carrying a larger degree of data than what's necessary. And in many ways, they can actually limit the security requirements depending upon the specific use case or where that data is flowing within their environment.
Yeah, that's one of the biggest. There are a number of different risk mitigation options, I'll call them, in terms of supply chain risk for CMMC, but that's one of the biggest ones. And that starts at the very front. That starts at the program office, prime contract level, in terms of how they're marking stuff, what they're marking, what's the criticality, why are you assigning a level 2 or a level 3 to this specific system, that kind of discussion. And then from there, that flows down into our networks, our prime contractor networks, but then also, even more importantly, flows down into the subs. And so are there situations, and the answer is yes, where we currently are sending supplier X a ton of information and data that's either mislabeled or is not necessary to complete their task or their scope of work? And can we be smarter about that? Can we be more, nimble and surgical on that to make sure that we're helping them out? Because they're, otherwise we're going to drive supplier X out of the dib. And so are we going to do that, or are we going to work with them and try to figure out, is there a way to make this work for them?
Yeah.
And I think one way that the final rule, I think the 32 CFR final rule did that, was talking about kind of the virtual desktop option, where a higher tier contractor can share information on their computers, but not allow it to be downloaded in certain ways, to allow those lower tier contractors to not take the information in, so they don't have to have a system that is compliant with level 1 or level 2, I should say, or level 3 in some instances. Is that an option, do you think? We'll go with you first, Michael. Is that an option you think large primes that you see are taking, or even smaller contractors?
I think some are. I think the challenge, I was pleasantly surprised and happy to see that specificity provided in the guidance. I think that's important in some use cases. I think the challenge is, the VDI only takes you so far. I think you really have to look at you have to always follow the data, as we say, right, and see where it's going. And so if you're accessing on a VDI, but then you're sort of pulling down that data, maybe if you're even prohibited from downloading it, but if in some other way you're ingesting that data and then putting it throughout your system for some type of manufacturing processes, you still are putting that CUI on your network, and that's what you have to be mindful of. If you can operate entirely within the VDI on kind of the parent or prime environment, that's, you're golden. But again, you really have to be mindful of again, where that data is going.
Yeah, I would agree. I think the technical details of any type of virtual desktop solution could absolutely matter in case by case, because There are going to be a whole bunch of suppliers where it might work, it probably will work, but there's going to be a whole bunch of suppliers where it's just not feasible, and you're going to have to look at other options to help them out in those situations.
Yeah, I think that's all excellent points. And one thing that has been talked about some, but I think kind of demands some more attention, are the affirmations that companies have to file at different points, right? So level 1 self-certifications, it's an annual affirmation. There's no POEMs for level 1, of course, for the 15 and 17 controls. For level 2, an affirmation has to be filed upon completion of an assessment, after POEMs are cleared, and then on those other kind of off years, right, between the 3 years. And those affirmations create a legal risk, of course, because they tell the Department of Defense that you've done something in particular. Michael seems itching to talk about the affirmations, and I don't blame him, because I think it's a really big hook for the Department of Defense to hold contractors accountable, and that leads all the way down, of course, to the False Claims Act. Michael, your thoughts on affirmations?
As an attorney, I don't like it. At the same time, I do like it because it really requires us to engage with our clients and saying, you need to take this seriously. That, again, the affirmation itself, you are attesting to the government, you're making a formal representation, and that is binding. You're binding yourself to a government, to a promise to follow through with that. And I think what was so notable with the final rule is that the affirmation is not sort of a one and done requirement or certification. It's a multiple instances. It's at the initial onset. It's if you have any POEMs. It's as you close them out. It's upon the final certification. It's every year annual thereafter. There were repeated representations that industry is required to now make to the government, and that's significant from a False Claims Act perspective, because when we look at DOJ enforcement actions and at our firm, that's sort of a whole other area of our practice that's exploded over the past 3 years, where there's rampant enforcement and settlements that are occurring, and so many of those are upon the government saying, you contractually agreed to follow these terms and you failed to do so, and we're holding you accountable for that. This requirement now, the affirmation, is only in elevating those requirements and making their enforcement even sort of more stringent. I think the other thing to think about, even in the drafting of the rule, that there really was a lot of coordination between DOD and DOJ. Again, at that fireside chat that we hosted on Tuesday with Ms. Bosjanek, she was speaking to that degree of coordination, and we rose, even within the CMMC final rule, if you looked at now, there's a requirement for artifact retention, meaning any of the documents that sort of serve as evidence how you meet any of your various controls are now required to be maintained for 6 years. And asking my other attorney or either my two co-attorneys on the panel, does anyone here know what the FCA statute of limitations is? How many years?
Well, it's that long.
Exactly. And is that a coincidence? No. And that was precisely the discussion that we had on Tuesday, was that, again, that there really was kind of a concerted effort of sort of engaging and partnering together. And I think that that should be sobering to industry to take that seriously. And, on the topic of supply chain, even some of the recent settlements with regards to the False Claims Act pertain to various invoke subcontractors. This last summer, Guidehouse had a settlement for $11 million, and the settlement did not apply solely to the prime, but also to the subcontractor Nan-K Associates. I think that that should also be really sobering to any of you within the supply chain, that not only is the prime contractor on the hook, but the subcontractors are too. I think similarly, when we look at the recent Penn State settlement that occurred just last month for a little over $1 million, originally the key TAM suit was really focused on sort of misrepresentation with regards to NIST compliance, but when actually the government intervened, what they focused on was, in one aspect, their cloud security requirements, and that also is an extension, of the supply chain, that the various cloud service providers that were being used were not FedRAMP moderate equivalent, and that was precisely the area that the government focused in on. All this to say, there is legal risk to the supply chain that you really should be mindful of.
Yeah, absolutely. Chris, what are some of the challenges you see with the affirmations? As somebody who's in-house.
I actually, the challenges for us, it's going to be how are we bringing them up through the supply chain? How are we collecting them? How are we doing it to the prime contract? In terms of, from a risk perspective, I guess, the kind of the affirmation or certification from a supplier, I like that. I feel more comfortable with that versus the current, we'll call it the current way that we do things, which is, the flow downs and then kind of put your head in the sand and hope. I think that will be beneficial, to the tier 1 defense or tier 1 prime contractors, and even below that. I think the trick is going to be, like I said, it's going to be how are we bringing those up? Are they accurate? You know, all that kind of stuff. Those are the risks that remain to be seen.
Right, and just kind of talking about, you know, the affirmations provide a good kind of guidepost for companies when they're kind of thinking about their systems, because systems change over the course of time, right? The system that was attested to or assessed may be different than the one that you have today versus a year ago, or your clients. And of course, if a system changes significantly enough, the contracting officer is supposed to be made aware within 72 hours. And that means that the assessment that you had is no longer valid as a company. And that presents a lot of challenges. That can happen, as an example, for an M&A transaction, where you bring some systems together. Or it can happen just because you want to upgrade the system and have a better system. And that could change the scope of the system that was assessed. And that challenge is, how do you have a seamless transition over to that new system that would also be assessed, right? Because if you're telling the contracting officer your scope has changed and your system has changed enough that you no longer feel comfortable saying it's the same system that was assessed, within 72 hours, the contracting officer then has the power to terminate that contract, right? They have the power to terminate a contract anytime, for better or for worse, from a contractor's perspective, for worse. But they have that power to terminate, but then, you know, that they have the knowledge and the risk if they continue with that contract, knowing that that contract is being supported by a system that hasn't been assessed because it's a different system now. Michael, just coming back to you, what are some of those challenges that you see when you're kind of changing your system for whatever reason, and the potential outcomes for a company dealing with a contracting officer when that happens?
I mean, I think the thing to be mindful of is, again, you know, I always think through it when I'm counseling my clients is really, how will the government think about this, and what will they be curious about? What will they be interested in? Sometimes, you know, we can engage and not really sort of think to the end goal of really how would the other side sort of receive that information, and what would they be wondering. And so I think when we're talking about system changes, I mean, I think the immediate thoughts I have was what's happening to my data. You know, even with regards to a key system change, I would even think on the topic of our panel, how is this affecting your supply chain? Are you bringing in scope other suppliers? Have you accounted for those? I think even as a CEO, I would be really curious about that. Have you flowed down these requirements to other subcontractors that may not originally be within scope but now must possess a CMMC certificate, and where are they in that process, even if we're in the early phases of implementation?
Yes, and I guess, Chris, that would present a challenge for a larger contractor like you work at, where you have suppliers that maybe have system changes and you're reliant on those products or services from that supplier.
Yeah, that's going to be a major risk, and that this topic or this issue goes in my bucket of unresolved CMMC 48 CFR issues, right? This is something, there were a lot of comments on this issue. I will be intrigued to see how this plays out when the final rule comes out, because you're right. I mean, there could be all up and down the supply chain a number of questions that probably will ultimately come across my desk in terms of, is this a change that needs to be provided up, you know, up the stream? So I think that's going to be, there needs to be some sort of standard, there needs to be some sort of threshold out there. Otherwise, we're going to be kind of putting our finger up in the air and seeing which way the wind's blowing, figuring out what is and what isn't, right? And I think it does come back to the data.
Yeah.
And because that's the central premise of the whole CMMC program, is protecting the data. But even there, you still have kind of a squishy argument or standard, right? You don't really know when you trip that wire. There are instances I can see where it's clear and dry, right? You know, an M&A, let's say, is probably going to be one, but if you just start adding a couple new pieces of technology or you know, that kind of thing, is that an actual change that needs to go up?
Right. Kind of the interesting way that at least the proposed rule under Part 48 of CFR is that they really connect each contract to each system that's going to be used in that contract. There's a unique identification number tied to each system, and that unique identification number is given to the contracting officer so they know which systems are being utilized for that contract, which I think is a really kind of interesting way to tie everything together, and it kind of gives the government a lot of visibility into what the contractor is doing.
Yeah, and I think that's going to help at least from a prime contractor perspective, because like I said, in our world, we're going to be level 2, level 3. And so are we going to have, hopefully we're going to have contracts that certain systems are going to be level 3, but others will be level 2. and you'll be able to, again, mitigate some of that supply chain risk where, whereas, a level 3 big-time contract of ours, we can't have all our suppliers meeting level 3 requirements, or else we just won't be delivering any ships.
Makes sense?
Not a great outcome there.
No.
Well, you mentioned the levels, and I think it's important to talk about them. You may have heard in the audience here that there are 3 levels for CMMC. There was once 5 back in the day, but I think that should be a test like before you come in. Do you know that there are 3 levels? I don't know. But those 3 levels are really important, right? There's the level 1 contractors only have to self-assess. And Michael, I'm going to come to you next. I'm just warning you.
Uh-oh.
But level 2 and level 3 require a third-party assessment of different kinds, right? A C3PO for level 2 and from the DIPCAC for level 3. And you may have contracts where the contract you think if you're a company, you think the contracting officer, program office got it wrong and assigning a level 2 to a contract that should really be level 1. Yeah. And the answer to that, right, of course, is a pre-award protest, which warms my heart, of course, and Michael's heart as well. But it does disrupt kind of the flow of how programs will work. Michael, what kind of risks do you see on the different level assignments and how contractors and companies can deal with that, especially if they think the level assigned to a contract is an error?
Sure. I mean, I think you sort of touched on it with the protest mechanism, but I mean, I will state on the record, I became a cyber attorney because I didn't want to touch a protest anymore after retiring from the government, so you can call some other...
Don't blame you.
But I mean, obviously that sort of is one approach. I mean, I think another way to ideally get ahead of it again would be during the actual solicitation phase, like during Q&A, trying to engage early on, or if there's even a draft RFP or an RFI, if you're seeing earlier markings in a statement of work, really get ahead of it and track your requirements. And again, engage with your program offices. Try to attend every industry engagement event that you can, that whatever relevant agency or component agency is sponsoring, so that you can really connect with those key individuals that are actually driving the program requirements. Because again, speaking from, a former CO perspective, I think what we found often challenging is that you're getting documents from your program office and you're really trusting them to be the SMEs. And so as the CO, you have a certain degree of deference to them. And so if there is a misunderstanding, or even if you have, just a really zealous PM that thinks everything should be level 3, when really that's really off base, it will take someone else sort of bringing that to light so that you can run it down and ideally try to resolve it.
Yeah, and that goes back to my communication, on the front end, but then also making sure we're having that discussion not only as it pertains to us, but how is that going? And then it's really incumbent upon us as the prime contractor to say, okay, we've had these discussions with the program. This is what we think. There might be a couple areas where we might be in dispute, but by and large, we're kind of there in terms of levels and systems. So now it's incumbent on us to start matrixing that and going down and saying, here's our list of suppliers for this program that are going to be level 3. Here's our list that are 2. What do they look like from a cyber perspective? Where are the gaps? Where are the criticalities? That's going to be incumbent on us, but it all starts with the discussions on the front end.
And I think what you just described there, kind of that critical supplier matrices, is so pivotal, specifically for the contractors that have a broader supply chain, or where they're engaging with many suppliers, that again, you might determine until you actually look really closely at your various contracts, that certain ones you only have 1 or 2 key suppliers that can only perform these functions. And as you begin engaging and seeking either a rep insert from them, you may learn they're unable to actually meet it within your timeline, and you could even be in default under your contracts because you're unable to perform. So really, I think the prudent recommendation would be to know your contracts now and know who those critical suppliers are and where they are in their current cyber posture.
Right. The timer up there says we have about 3 minutes left. So
I interpret that to mean we have 13 minutes left, but...
Oh, okay.
No, I'm joking.
Well, Michael and I get paid by the word, so it's however long. We'll stay up here all day. But I wanted to use this remaining time just to kind of talk through some wrap-up thoughts on best practices. So, Chris, I'm going to come to you first. For those, especially for those subcontractors in your supply chain or other subcontractors in other supply chains, what are some best practices that you could recommend for those folks?
Yeah, absolutely. So, obviously, if you're a supplier in my world, you hopefully have already started this CMMC preparation in terms of either you're doing it internally, if you have the resources to look at the controls for level 2, let's say, and start preparing those artifacts and making sure you understand what that looks like. Or if you don't have the resources, going to an outside entity, an RP, to come in and help you with that. I think before even that starts, back to the communication piece, reach out to your prime contractor or prime contractors to start having that dialogue. What do they think? What are they hearing? Because we are, at least our company, we are talking to the government on this. What are they thinking about levels, right? Here's, offering your opinion as the supplier or the subcontractor, listening to what the prime's saying. Let's make sure we're not in a situation where I would deem a failure on my part, where we're in a solicitation phase, trying to go to a critical subcontractor for the first time, realizing that they think they're a level 1 when in fact they have to be a level 2, or level 2 versus 3, right? I think that's a failure. So it's that communication on the front end now, and then doing that preparation work to see where you're going to fall. And another thing is timeline, right? The timeline and the resources for the available C3PAOs is going to be interesting to see how this plays out. I know they're going to phase it in the different phases, but even then, trying to get in that queue is going to be critical.
Yeah, I'll just, Michael, any wrap-up thoughts? We've got a little less than a minute left.
Yeah, just one other quick thought too, to that same point of determining as a supplier, where you fall, what your requirements will be. Something else that we often counsel a lot of companies on is understanding when they actually are handling CUI, and that often can be really challenging for manufacturers where you're receiving documents, they're not marked, but you're receiving flow-down requirements. Again, it's not as simple as just looking for a marking. There's a lot more nuance to that, and that's why you sort of need legal counsel. But I think even as a starting point is engaging with your prime and asking them, what are we receiving that is CUX? We see these clauses, but we want to understand so that we can safeguard it accordingly. That's the starting point, but you really need to look closer into that.
Yeah. It's great points. And I'll just add one thing really quick. CMMC, the structure of CMMC may change one day. It's changed before. It could change again. But one thing that's always been constant is the requirement to comply with NIST 800-171. Right. So there's no harm, no foul in getting right with 800-171 if you have controlled and classified information. It will not be wasted money. It should not be wasted money, I'll say. I don't want people coming back to me if that does not be the case. But it should not be. That's been a consistent theme of the government through all these changes, that NIST 800-171 is the standard that they want folks to comply with. So there's no harm, no foul, making sure you're square with NIST 800-171 at this time. So I appreciate your time. I'll pass it off back to Mark, who's patiently waiting off his security. So it concerns me a little bit.
I see some boxes.
Supply chain security.